Good afternoon and welcome to LawFest 2020 and this panel on religious discrimination legislation. My name's Dr Matt Killingsworth and I am the Head of Politics and International Relations and the coordinator of the Bachelor of Justice Studies here at the University of Tasmania. To begin with, it is important that we acknowledge the traditional owners of the land on which our meeting is taking place, and as such, as a reflection of this institution's recognition of the deep history and culture of this island, University of Tasmania wishes to acknowledge the Muwinina and Palawa peoples, the traditional owners and custodians of Lutruwita, Aboriginal land, sea and waterways, and pay respect to elders past, present and emerging. Now, before we start our Q&A with Anja Hilkemeijer, we've got a few little housekeeping notes that I'd like to run through with you first. Microphones, video, chat, and raise hand function have all been disabled in order to protect your privacy. If you encounter any technical issues, you're able to communicate with the panel using the Q&A function at any time. The webinar is being recorded, but you're not being recorded in any way. And obviously we've got questions that you have all forwarded to us via your class teacher, and we'll move on to those with Anja in a second. And I think it's also important that I remind you that if there's something else you want to ask today, we've also got a Q&A session at 3:30 this afternoon. So the questions, and our subject matter expert today is Anja Hilkemeijer, who is a lecturer in the University of Tasmania's Law School in Constitutional Law, Human Rights and International Trade Law. Anja researches in the field of human rights and has a particular focus on the intersection between discrimination law and religious freedom. So we've got a set of questions, as I mentioned, that we have that have been sent through. And Anja, if it's all right with you, we might get started on some of those questions. So I'll read out the questions to Anja, and obviously Anja is aware of them as well, and I'll say who they've come from too. And obviously, please don't hesitate to use the Q&A function, perhaps if we've got time and you might want to elaborate on any of those questions. So the first question is from GYC Glenorchy campus, Anja. And the question is, how effective has the Anti-Discrimination Act of 1998 Tasmania been?
Thank you, Matt, and thank you everyone for your questions. I thought they were really brilliant and showed really great understanding of what's really complex area of law. We've got international law, domestic law, state law, federal law, common law, human rights. It's a great mixed and very confusing bag of law. So I was really impressed. And this is a really good question to start with. And my view is that the Tasmanian Anti-Discrimination Act does a really good job. And it's partly because it was actually enacted quite late in the piece, quite some time after other states had enacted their discrimination laws. And the Tasmanian Parliament learned from that experience to draft a law that's very clear and has worked extremely well for the last 22 years. So I think that's a really good starting point.
So we've got an idea of how effective it's been, which is a nice place for us to start. We've also got a question from Rosny College that questions the need for a federal religious discrimination legislation. And the question here is whether it's needed, or is it essentially a copy and paste of the 1975 Commonwealth Racial Discrimination Act?
Yeah, that's also a really good question. Now, the Racial Discrimination Act does provide some coverage in terms of religious discrimination, and that's through the inclusion of a prohibition of discrimination on the basis of a person's ethnicity. And the courts have interpreted ethnicity to extend to protection from discrimination of people who are Sikh or Jewish. But it doesn't provide coverage for all religions. So there is a need at the federal level for a law that says religious discrimination, any religious discrimination is prohibited. But we have to be very careful to distinguish the prohibition of religious discrimination reflected in Article 26 of the International Covenant of Civil and Political Rights from freedom of religion, freedom to manifest or practice religion, which is in Article 18. And the bill tries to do both. Now, while the first thing I think is really necessary, the second thing is more problematic.
Hopefully we might have time, Anja, we might want to talk about the intersection of domestic and international law, as you mentioned there, with the two different pieces, international treaty and domestic legislation as well. Our next question is from Collegiate. And the question is about the CRICOS principles. And what are they? And does this draft legislation, and you might have to clarify which draft legislation the question's referring to, does this draft legislation live up to these principles?
Yes, now this is a good question. You often see the CRICOS principles referred to. The CRICOS principles were drafted and adopted by a group of lawyers in 1985. In fact, they're the American Association of the International Commission of Jurists. So they're not an agreement between states in the way a treaty is. But states often refer to them, so they do carry some weight. And to a large extent, the CRICOS principles are consistent with international human rights law. So what are the principles? Because they're really, really important. The principles are that those human rights that can be limited, and most human rights can only be limited if a number of conditions are met. And that is, the limitation has to be by law, the limitations have to be clear, they can't be arbitrary, they have to be reasonable or proportionate, and in pursuit of a legitimate goal. So those criteria really are a measuring stick for judging whether or not the religious discrimination bill, this draft bill, complies with Australia's international obligations. And I think I already said in my podcast that in a number of respects, I don't think it does. I think you'd all agree with me if you've looked at it, the bill is far from clear. It's also broadly worded, which means it's subject, to arbitrary application. But most worryingly, it's capable of application in unreasonable ways. And what I mean by that is it's capable of applying in ways where in order to protect religious freedom, significant harm is done to other rights. And there are a whole range of rights that can come into play here. And that might be rights to equality, but also the rights of people to work, the right to privacy, the right to family life. And by giving quite broad rights to religious organisations and religious people, the rights of others can be impacted in unreasonable ways. Now, and I'll just finish, this is my long answer, but I'll just finish with one example because I think it's quite important. And that is courts in countries that apply human rights law. That's not the case in Australia, but it's the case in most other Western liberal democracies. They've said very clearly that the rights of religious organisation to protect what's often called their right to religious autonomy will never trump the right to equality, because equality is this very, very important principle in human rights law. So, for example, a Dutch court held that a conservative religious party could not prohibit its female members from standing for election in the Dutch parliament. So in those circumstances, you see applying a holistic human rights approach, attaching weight both to religious freedom, but also to the importance of equality. In those cases, the courts have said that equality will trump. So that's my long answer to a really important question. But we'll come back to that, I think, in some of the other questions. Yeah,
indeed. Excellent. I really like this next question because it works on the intersection between politics and law and the development of law. So this question is from Claremont College. And the question is, how likely is it that the Attorney General will act on the recommendations made by the Human Rights Commission to change the latest draft of the Religious Discrimination Bill?
Yes, that's a little bit of guesswork, but my feeling is that it's unlikely. Now, we had the first iteration of the bill and extensive comments, including by the Human Rights Commission and many other people. And in response to that, the government did make some changes to the second draft of the bill. So, for example, they expanded the scope of the kind of religious organisations that would be exempt from laws, so to also include religious hospitals and aged care and accommodation services. And but they restricted the kinds of health professionals that could be exempt. So now we just have doctors, nurses, midwives, psychologists and pharmacists, and the list used to be much longer. So they've already done some of that tinkering and changing. And my feeling is they're not going to change it much more. Of course, as Matt will know, the normal practice with bills of this kind is once they're tabled in Parliament is that they're sent off to a Senate committee for public inquiry. Now, we've had a lot of inquiries on religious freedom, but we've never had a public inquiry on this bill. And of course, the Ruddock inquiry was not a parliamentary inquiry. It was an inquiry conducted behind closed doors. And so it will very much depend, Matt, on whether the government has the numbers in the Senate, whether or not that will happen.
And obviously this is a particularly sensitive issue for government and for sort of political polarity as well, because it plays into political parties and ideologies on notions of rights, notions that include religion as well. So, and at the moment, an especially sensitive issue and the way that it will play out. Brilliant. All right, so we've, oh, I like this one too. This is a really fun legal question, actually. So this question's from Elizabeth Colley from EC. And the question is about the consistency of law. And if this bill is not consistent with human rights law, how can it become an act? And I guess who determines that as well? And if this is passed, what process will be in place to make the law consistent with human rights law?
It's a good question, Matt. So, of course, the starting point is that the Australian Parliament can enact laws contrary to Australia's international obligations. And we all have to be very, very clear on that. We have a dualistic system, and no obligations Australia has under international law limit its capacity to legislate. However, our Commonwealth Parliament can only legislate if it's on a subject matter that's listed in section 51. So if it has a head of power to legislate. Now, to some extent, the corporation's power might provide support for this law, certainly in relation to religious organisations. But much of this bill will have to rely on the external affairs power. And that is where things might get interesting, because in order to rely on the external affairs power, the government has to show that this bill is a proportionate implementation of precise obligations in that treaty. And of course, the International Covenant on Civil and Political Rights, which is the principal treaty here, is a treaty that takes a holistic approach to the balancing of rights, as I've mentioned, under the CRICOS principles. And to the extent that this bill kind of cherry picks and perhaps doesn't give enough weight to protect other rights, there may be a constitutional challenge on the basis that the bill isn't supported by the external affairs power and isn't supported by other things, leaving the corporation's head of power aside. Now, I'm reminded of the last part of the question, because the other thing to be mindful of, but it's a more extreme consideration, is that under the ICCPR, Australians have the capacity to make a complaint to the Human Rights Committee. And you will all be familiar with the Toonen case in relation to Tasmania, the first case petition brought against Australia. So if someone does feel this bill is implemented and someone feels that their rights have been interfered with, that will be a possibility. But the Human Rights Committee, of course, takes a long time to make its decisions, and then those decisions are only recommendations. The government doesn't, and usually it doesn't have to, and usually doesn't comply with those recommendations.
Much to our frustration sometimes.
Yes.
We've got another question with respects to the role of government and hence politics from Launceston Grammar. And this question is, the AG gave terms of reference to the ALRC, but the bill has already been drafted. So this is a similar sort of an add-on to a question that you've already addressed, Anja. So according to the ALRC website, they have until 12 months after the bill has been passed in both houses of Parliament to hand down their report. So the question is, what's the point of the ALRC reporting after the bill has been passed?
So Matt, this is also very much a question about the interaction between politics and law, because the initial request went to the ALRC to look at the existing exemptions for religious organisations under the Sex Discrimination Act, including to be able to refuse enrolment to LGBT students. And at that time, which was late 2018, the government was under a lot of pressure. There was a media furor. The Greens and Labor had introduced a bill to take those exemptions out of the Sex Discrimination Act. And it was a perfect political move to create some time, some delay by saying, oh no, let's give it to the Australian Law Reform Commission to have a full inquiry. Then in May 2019, we had the election and the government was returned, and the government decided to proceed straight away with this bill and not wait for the independent report. Now, of course, that was a bit of a problem. Well, what do we do? And so what we see now is the request to the Law Reform Commission has been altered and really become very minimal and technical. And the Law Reform Commissioner has admitted that. she herself appeared before a Senate inquiry and said, all I'm asked to do is once the Religious Discrimination Bill is law, I look at the other acts, and here this is principally the Sex Discrimination Act, and I draft a section to recommend how to bring that in line with the Religious Discrimination Act. Now, my concern is that the exemptions for religious organisations under the Religious Discrimination Bill are even wider than those under the Sex Discrimination Act. So once the bill is enacted and the Sex Discrimination Act is then made consistent with it, the bottom line will be we'll end up with even wider exemptions than we started with all the way back in October 2018 when the Ruddock, you know, in terms of what the Ruddock report kind of brought to public attention.
Does that defeat the idea of a racial discrimination act then, with so many exemptions?
For the Racial Discrimination Act or the Religious Discrimination Act?
Sorry, the Religious Discrimination Act, sorry.
Well, yes, yeah, so the focus has been on the extent to which the Religious Discrimination Bill might undercut protections for non-discrimination in relation to sex and sexual orientation and gender identity. But of course, the Religious Discrimination Bill, in its exemptions, allows religious organisations to discriminate on the basis of religion. And that means large religious hospitals or schools or welfare organisations, both in who they employ and in who they provide services to, potentially could refuse those services or refuse to employ people not of their religion.
So this is a nice segue actually to a question that we've got from Rosny College on what's the effect of this on private businesses? And the example that's being cited here is the example of the Christian baker. Now, I'm probably more aware of this example in the US than I am here in Australia, who refuses to bake a wedding cake for a same-sex couple. How would this legislation affect a service business such as a bakery?
So you're absolutely right, Matt. This problem is quite a prominent problem in the US. The Ruddock panel, when they conducted extensive secret consultations, found it's not really an issue in Australia. And this bill doesn't provide any rights in relation to it. This bill doesn't deal with it for private businesses. However, it does allow religious organisations to refuse services. And that's an important thing to remember, particularly since religious organisations are quite pervasive in health, in aged care, as well as in a lot of welfare delivery. So that is a consideration there. But the bakers, no.
And does that include education as well? So religious-based schools as well?
Absolutely, absolutely.
Okay, all right. I skipped a question there. I got out of sync, sorry, because there was a natural segue there. So our next question is from Elizabeth College. And the question is, how would the RDB interact with existing anti-discrimination legislation? So you've addressed some of this as well. And how would this impact upon the rights of individuals and religious organisation in states where this legislation exists? I think we've covered a little bit of this already,
yes.
But if you could just clarify maybe.
Yes, so of course that's a question of Section 109 in the Constitution and the fact that the federal law will prevail over an inconsistent state law. This has been a grey area in the past, but there's no doubt that if this bill is enacted into law, people who may have had claim brought against them under state law will seek to rely on this Commonwealth law virtually as a kind of defence, but will seek to justify what they've done as being their entitlement under this law. And that could be pharmacists who refuse to provide contraceptives. It could be people who've engaged publicly in offensive speech. It could be a whole range of things.
So and this next question segues nicely from your answer there as well, and it's in relation to the concept of good faith. And the question is that the bill states that a statement of belief would not constitute discrimination if made in good faith, unless it meets a higher threshold of vilification. Hypothetically, how would the phrase good faith be interpreted by a court?
It's very difficult, and good faith is mostly a subjective test, and of course it just goes to honesty. And there has been a case of Hozak where the federal court has looked at this, where someone was sacked by a religious organisation because she was in a de facto relationship. Other people employed by the organisation had also been in a de facto relationship and not be sacked. So you might have thought that was not acting in good faith, but the court held, well, actually it was. We just looked quite narrowly. In that situation, they acted honestly. It's not entirely clear-cut. In the case of Grofo, Chief Justice French suggested that there is a slight objective element perhaps, but largely good faith is a subjective test.
Just a reminder to people who are on that they've also got the opportunity to ask questions using the Q&A, the chat prompt down below if they'd like to follow up in the 5 minutes that we've got left. We've got a next series of questions have all come from Collegiate, and some of them cover issues that we've already spoken about, but nonetheless, I think there's some value in going through. So you've addressed the question here, that is, how will impact on the ability of a religious institution to terminate employment? You've made that quite clear, that there is quite a large latitude with respect to this bill for religious institutions to terminate employment.
Absolutely right. That's absolutely right. And that's not consistent with international law, because international law says in some circumstances, say for example, for a really highly spiritual organisation, there was a leprosy organisation that really continued sort of Jesus' spiritual mission to heal lepers, and the everyday work of the organisation involved everyone in spiritual activities. And the court said, well, in those circumstances, it's reasonable that all employees, even the accountant, had to be Christian. But in other circumstances, that may not be relevant. So if you're looking at say a hospital where you have cleaners or cooks fulfilling really secular roles, the court says in those circumstances, those people's right to work and to privacy will prevail. And so the problem with this provision is that it's a sort of sledgehammer that doesn't take into account other people's rights.
And this is a particularly pertinent question, again, from Collegiate at the moment. And I'll be fascinated for my own personal knowledge as well, that how might the proposed religious discrimination legislation or the present state-based legislation indeed impact on the ability of people of faith to object to vaccines, for example? And the particularly pertinent one at the moment is a COVID-19 vaccine.
Yeah, interesting. The answer would be no, it doesn't affect their right at all under this bill, because remember, it's about religious discrimination. But there's one part of it that would have an immediate impact, which is that the bill would allow religious doctors, nurses, pharmacists to refuse to prescribe or sell the vaccine. So that's kind of an odd result of this act. But you've got to be mindful of the fact that there wouldn't be nothing stopping any kind of legislation around compulsory COVID vaccination to include exemptions. And lots of Australian laws have exemptions for people in an even-handed way, in all sorts of ways. So it wouldn't be that there couldn't be an exemption, but this bill wouldn't provide it, except for medical practitioners and pharmacists.
We're coming up on our allotted time, and I think we've got time for one more question, if that's all right, Anja. And this is a question also from Collegiate, and it points out that recommendations 17 to 19 of the Ruddock Report seem to be more concerned with promoting an understanding of the lived experience of peoples of faith, with a view to creating a culture of greater acceptance. Is anything being done with respect to these recommendations, or is this priority getting drowned out, and in scare marks, in the current debate?
Yeah, I think that's a really kind of sobering note to end on, because I totally agree with that question. And I think, in fact, what's happened is that this law, by being so extreme in so many ways, has a polarising effect on the debate. And what we don't see from this government, and which the Ruddock panel spent 3 recommendations on, is to say it's really important to research, but also to educate people about the importance of religious diversity, and to identify areas where people of diverse religions are subject to discrimination, be it in employment or housing or education or other fields. And that what's the purpose of discrimination law, of course, is to create a society that is more tolerant of diversity, and rather than one that kind of buttresses greater polarisation. So I think that's a really more of a very thoughtful comment rather than a question. I think that's really important to reflect upon.
Yeah, I agree. And I like your comment as well on the idea of legislation such as this is not designed to further polarise. I think that's really pertinent to consider, sort of the underpinning idea and aim of the legislation as well. which I think is always important. Brilliant, Anja. Thank you so much for your insights on such a topical issue, obviously, because our legal studies students are doing it this semester, but I think also an issue that even if they weren't doing it is of great significance to both law and politics and society more generally as well. So thank you so much for your time and your engagement with these questions. For those of you who didn't get the opportunity to ask a question, or if you thought of something in the meantime, please join us for the Q&A session at 3:30. And if you need to join on that, you can receive the link to the session via email, completing the registration on the LawFest webpage. So I hope you enjoy the rest of the afternoon. Thank you again, Anja. And I look forward to seeing you in further Q&As this afternoon. Take care, everyone.
Thank you, everybody. Well done.